All right, folks. Again, my name is Doug Pinkham with Pinkham and Associates. I am now going to go over the child support information and order attachment. This form is also attached to some other form. It's either attached to a judgment when there's child support orders, or it could be attached to a request for orders if you're asking for child support, or a responsive declaration if you're asking, if you're responding to a request for child support. Anyway, it could be attached to a findings and order after hearing or a judgment, whatever. So, like all of these forms, list the petitioner's name, the respondent's name, and the case number at the top. Then you're going to mark the box right underneath the title at the top of which form this is attached to. Judgment, findings and order after hearing. It could be other, and it could be a request for orders, whatever it's attached to. Keep in mind, I know that some of you can see the form, others of you cannot see the form. If you cannot see the form, please hit the link below, print it out, and follow along line by line as I go through these forms. All right, folks. So we're going down a little bit further. It says, court used the following information to determine the amount of child support. So either you guys agreed on some numbers, or the court used, or that you have used a disomaster or an ex-spouse child support calculator to figure out how much child support is needed, or is actually the guideline amount. That's the key word you want to remember, because the court is, it's mandatory for the court to charge the guideline amount. Okay. All right. So number one, printout of the computer calculation and findings is attached and incorporated in this order for all required terms not filled out below. So if you've got the ex-spouse or the disomaster or child support calculator, and you've put all your information in there and can print it out, you can attach this. It's probably going to have all these numbers, so you don't need to add them. But if you don't, you need to add the information in here. If you've attached it, go ahead and mark 1. If you have not, mark 2, and you're going to need to fill this information in. You're going to need to put petitioner's gross monthly income. You also want to put net monthly income after taxes. If you don't know what it is, leave it blank. If that person is receiving CalWORKs or some other aid, you're going to need to mark that box. Okay? If they're not, leave it blank. Then we move on to respondent. You're going to need to list the respondent's gross monthly income and net monthly income if you know it. Keep in mind, folks, you need to put a number in here, or the judge can't figure out child support. You need numbers to put in the calculator. Again, if the respondent is on a TANF or CalWORKs, you need to mark that box over here. Other parent, it's not likely to be in your case, so I'm not even going to talk about that. Imputation of income B. The court finds that the petitioner or the plaintiff or the respondent or defendant has the capacity to earn, and then there's a blank for an amount per month or per week or per hour as based on his support order, blah, blah, blah. Okay, now listen. Imputation of income is something that you're going to have to argue, and a judge is going to have to order. The judge has to make specific findings, has to make rulings in this area. So if you haven't done that, that's not likely the case. So if you haven't been to court, this doesn't apply. This section doesn't apply to you anyway. All right, folks, moving on. 3, children of this relationship. So number of children with regard that are supported, or excuse me, subject to this support order. If you've got 2 kids, put 2. If you've got 5 kids, put 5. If you got 1, put 1. Next section, the percentage of time, the approximate percentage of time with the petitioner and the approximate percentage of time with the respondent needs to be in here. Let me give you a trick on how to figure this out. The way I do it And the way I know that most judges do it, when they want to be exacting. There's lots of judges that just say, okay, if you're with a kid for 8 or 10 hours a day, that's 24 hours. But that's not good, in my opinion. Let's say, for example, I just had a case actually on one of my clients. Father watches the kids during the day. He watches them from 9 o'clock till 4 o'clock in the afternoon every day. He also watches them on Saturdays from 9 to 6. He watches them, and that's the 9 to 4 is 4 days a week. All right, and 9 to 6 on Saturdays, and then on Sundays, it was from 8 in the morning until Monday at 9 in the morning. So that is, let's start with the Sunday at 8 a.m. to Monday at 9 a.m. is 25 hours. And that is every Sunday, so that's 25 hours times 52 weeks, right? So 52 weeks times 25 hours equals, that's 1,300 hours. All right, let's take the 4 days a week from 9 a.m. to 4 p.m. That's 7 hours. So 7 times 4 days a week times every week times 52 weeks. That's 1,456 hours with Dad. Okay, then on Saturdays it's 9 to 6. So that's 7, 8, I think that's 9 hours. So 3, that's 9 hours. So 9 times, and it's every Saturday, so it's times 52 weeks. That's 468 hours. So add the 468 hours and the 1,300 hours and the 1,456 hours. Now, very oftentimes, you guys also agree to split holidays. Holidays, you need to figure out when they're going to be, from what hour to what hour, what days, how you're going to split it. But let's just generally say that there's going to be, let's say, 3 24-hour periods of holiday time. So let's say that's 72 hours. And then let's say that there's 1 week of vacation. That's 7 times 24. So 7 times 24 is another 168 hours. So we add that all together, and that comes out to 3,464 hours. Now there are 8,760 hours in a year. So divide that 3,464, or whatever your total is, by 8,760. And in this case, this father has 39.5% timeshare. And that's how we figure that out. Now this is not always this easy. I know it probably didn't sound easy, but this was easy. This one's easy for me. But it's not always easy, because if you have a bunch of different holidays in that week, and I'll give you an example. You know how I counted this week and I gave Dad the entire 168 hours? Really, that's not true. We have to take all of those weekend hours off that we already added above, because he's got 9 to 6 on Saturday, and he's got 8 a.m. Sunday to 9 a.m. Monday. So we don't want to double up those hours and count them for Dad twice. So theoretically, this is probably really more like 39.2 or 39.3% visitation. It's probably not that big a deal. So here you could put 39% for the other parent, and for you it would be the other portion, which would be 60.4%. So anyway, that's, so that's how we figure out timeshare. Keep that in mind, and you can use that to figure yours out. And by the way, those factors are needed to figure out child support. They're very, very important. The more time the children are with you, the more money you need to feed them, to house them, to provide electricity, to whatever those needs are. The more time they're with the father or the other party that's paying child support, the less they're going to pay, because they need more money at their house to pay for food and electricity and that kind of thing. That's how that works. All right, moving on to section 4, hardships. Hardships of the following have been allowed in calculating the child support. So If let's say dad or mom has other minor children from another relationship, that's where you would put this in there. And you can put, for the petitioner, how much you're paying for that child per month. Now, you're not going to get that whole benefit, but you can put that factor in there. B is extraordinary medical expenses. If there are regular medical expenses that you pay every month, put that in there. A judge will take this information and factor it in for a determination. And then catastrophic losses, insurance. There was an earthquake and your house was damaged. Any kind of catastrophic losses. Car accident, you just had to replace your car. Your own medical issues. Whatever that catastrophic loss was, you can factor that in here and ask the judge to take that into consideration when making child support orders. If the court has not made any of these hardship findings and you're filling this paperwork out to attach to a judgment or something, all of these are going to be left blank. Okay. 5, the court orders low income adjustment. So if, for example, one party has an extremely low income, the judge can make a low income adjustment. This has to be ordered by the judge. And B says the low income adjustment does not apply because, and then there'll be the reasons there. This also is something that you would be discussing in court and a judge would make orders. If there have not been orders made on this, it does not apply. 6, child support. Base child support. So we're going to mark this one. And then who's paying? Let's say that the respondent is paying child support. So we mark respondent must pay child support beginning, and there must be a commencement date. So when is child support starting? Starting tomorrow? Starting the 1st of next month? Starting 6 months ago when you filed your RFO? You need to know when the child support starts. You can't just pick an arbitrary date. But you can pick an arbitrary date if both parties agree to it. And obviously, if you pick a date 2 months ago and no child support has been paid, then theoretically the payor, whoever's paying child support, owes 2 months already. So if you wanted to just start now, then start, on the next first day of the next month. All right, below that, so make sure you put a date in there is my key. You must have a commencement date. And then below is pretty obvious. You're going to list the children, all the children's names, their birth dates. If you want to break down the amount of child support that's paid per child, let's say, for example, the entire child support per month is $1,000 per month. You might have, and you have, let's say you have 3 children. The youngest child might be $600 per month. It is going to be the largest percentage of the full child support order is going to be paid to the youngest. The middle child gets a little less, and the oldest child gets the least amount. That's just how it works under California law. If you want to specify, you can. If you want to say you got 3 kids and it's $333.33 for 2 of them and $333.34 for the third, that's exactly $1,000. You can do that too. You can break this down any way you want if you guys are agreeing. If a judge orders it, a judge is going to tell you how much for each child. Now, most child support orders are paid half on the first day of the month and half on the 15th day of each month. You can also have it all paid just on the first day of each month. However you want it paid, mark that just below there. All right, moving on to page 2. The court further orders. Now, 6 talks about mandatory additional child support. So if there is child care costs, generally speaking, child care costs are split 50-50. So in this section, just put 50% to the petitioner and 50% to the respondent. If one person is going to pay for all of it, mark the respondent or the petitioner's box, whoever's going to do that, and put 100% next to it. Pretty straightforward. Mandatory additional child support. And by the way, if you're going to have something in here, and I would recommend that you mark these boxes, generally I would put 50-50 here if there's not any other specific orders. So 50-50 like that. Reasonable uninsured medical costs. Almost invariably, this is split the same way. 50% to the petitioner, 50% to the respondent. It's very rare that one parent has to cover all uninsured medical costs. What are uninsured medical costs? Copays, medications, over-the-counter drugs, whatever it might be. Anything that's not covered by insurance that is a medical cost of some kind. Okay, again, almost invariably split 50-50. Additional child support, costs related to education or other special needs of the children. If there are some, you can split it 50-50. If there's private schooling and you're agreeing to split it 50-50, you can do that here. Travel expenses for visitation is D2. Go ahead and list that. Could be 50-50, could be all paid by one, whatever it takes. Let's say, for example, one parent lives in Texas and you have to fly the children over for visitations. The court may have ordered, the judge may have ordered that the party that moved away, they did it voluntarily, and maybe they make a lot more money than the person that remained behind. Maybe they have to pay 100% of all the travel costs. If so, that might be 100% to that party. Okay, and then E. E is non-guideline order. So if you are agreeing to, or if the judge ordered a non-guideline child support order, that's the number that comes out of the DissoMaster or the child support calculator. If you're agreeing to a number different than that number, then you need to pay attention here. There is going to be another form that's required. You're going to mark this box, and then you're going to need to do the FL342A attachment. It's a non-guideline support order attachment. And then you're going to put a total down here in the bottom for child support. And that is likely going to be the same number from the front page, $1,000 or whatever it is. If you have specific numbers in here on this page, under 6, then you can add those in too. So it'll be $1,000 plus whatever numbers they're here. If they're percentages like we've filled in, then obviously it's just going to be the regular child support amount, $1,000 or whatever it is. All right, then there's some information right there below. Health care expenses. Let's look at 7. Health care insurance coverage for the minor child of the parties must be maintained by. So either you guys agree that one party or the other or both will be responsible for the carrying health care coverage, or the court may have ordered one of you to maintain the health insurance for the children. If so, that's where this gets marked. And obviously, if the judge has not ordered, or you guys don't agree on one person maintaining the health insurance, then you can leave it blank. But I'm here to tell you, if you go to court, a judge is going to say that one or both of you need to get health insurance for the children, either through Covered California or for through your employer or whatever it takes. Judges want these children covered by health insurance, so just be aware of that. 7. If health insurance is not available to the petitioner or the respondent or both at a reasonable cost at this time. So you're going to mark that. So if neither of you have health insurance through your employer, that's where you mark B and then mark both of you. If it's not, if one of you is unemployed, say the petitioner is unemployed, then mark B and petitioner because it's not available to the petitioner. C says the party providing coverage must assign the right of reimbursement to the other party. So this is, you want to mark this if one party is carrying insurance, because you want to be able to work together. You need to be able to work together in this way. You must be able to work together. All right, moving on. Earnings assignment. This is just information. Read that. It's basically saying that if there's a child support order, then there will be an earnings assignment order that goes along with it. That doesn't necessarily mean that the collecting parent, the person receiving child support, is going to file the earnings assignment with your company and make the company pay out of your paycheck, but they can. So don't be upset if it pops up. It's very standard. Okay, and then number 9 is relatively new law. I think it's only a couple years old. Just read it. It basically says if there's any need to actually collect on child support arrears that the person collecting, blah, 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 you'll read it. There's guidelines on who can collect it and how much they can charge, that kind of thing. 10, employment search order. So this is very rare, but sometimes a judge will say that one party or the other must go out and try to find a job. It's very, very rare, so unless a judge ordered it, leave it blank. 11 is other orders. So if there's any other orders with regard to child support, that's where they would go in this section. Then notices, there's a bunch of notices here and you want to read this. Basically, 2 of these notices say that there are other forms that you need to attach. Anytime there's a child support order, you need to attach the FL-192. It's an information sheet. It's just information. There's no boxes or anything to check. I have a form on that, and we'll have it attached. We'll show you can have it attached. It must be attached. So then B is if this form is attached to a restraining order after hearing a DV-130, then the support order is issued. This form, FL-342, remain in effect after the restraining order issued from the DV ends. So it's just saying that once a judge makes the child support order within a domestic violence restraining order, even if the domestic violence restraining order goes away or when it expires in 3 years, 5 years, whatever it may be, 6 months, the child support remains. So that's just a warning. 13 says that there's a child support case registry form. It is an FL-191. I also have a video on that. That form must be filled out and filed with the court within 10 days of any child support order being filed. I suggest you fill out the 191 along with the rest of your paperwork and submit it with the rest of your paperwork. It needs to be filed anyway, and you don't want to have to try to remember to do it within 10 days later. Okay. This is an interesting little warning. Go ahead and read that. It's a notice. The legal interest rate is 10% on any unpaid child support, and that keeps growing annually. So make sure you pay your child support. You can get in serious trouble if you do not pay it. Let me check something real quick. Yep, good. All right, that is the entire form. That is the child support information and order attachment, the FL-342. I hope this video was very helpful for you. Thank you again. My name was Doug Pinkham with Pinkham & Associates. Thank you.